everyone. Good morning, YouTube, Facebook, Instagram. I'm going to wait for you guys to trickle in. Let me know where you're tuning in from. Say hi if it's your first time so I can give you a shout out. Let me know where you're tuning in from. Good morning, Tishipu on Instagram. I'm tuned in from Atlanta, Georgia. Hi from Texas. Good morning. Good morning. Okay, guys, let me introduce myself. My name is 𝐒𝐿𝐵 𝐶hidole. I'm an immigration attorney. I'm located in Atlanta, but we have offices in Atlanta and in Orlando, Florida. But we represent clients all over the United States and internationally with their family immigration matter. I'll be happy to assist you. You can call me 407-995-6567. You can also send a WhatsApp if you want to schedule a consult, 404-333-8751. Hi, Brandon. Good morning. Let me attempt to pin my number on here, 407. I'm like a horrible multitasker. 995-6567. Guys, just give me a second to type in my number or WhatsApp 404. Good morning, Harrington. 8751. Okay. Now, how do I pin it again? Let me see. Pin. Okay, so those of you on Instagram should be able to see my phone number, and you should be able to see it scrolling through the ticker on Facebook and YouTube. So today I want to talk about conditional green cards and removing conditions on your green card through a waiver. So for those of you who don't know, and I've seen this question come up recently where somebody asked, the person asked, oh, I didn't know that you could get a 10-year green card. I thought you always get a 2-year green card. So the first answer is no, you don't always get a 2-year green card. You get a 10-year green card if at the time you were approved based on marriage, you've been married for more than 2 years. You also get a 10-year green card for different other types of petitions that qualify you, i.e. if you submit a valid petition, you'll get a 10-year green card as opposed to a 2-year green card. So if you've been married for more than 2 years, at the time of approval, you'll get a 10-year green card. So it all depends. So what do you do if you have a 2-year green card? First, you have the first option, which is to remove the conditions with your spouse, meaning you and your spouse file and sign your petition to remove your condition. But sometimes marriages don't work, or there's something that stops you from, removing the conditions with your spouse or from your spouse signing. When something like that happens, then you need a waiver. And there are different types of waivers that you can submit with your application. So the first one is based on death. So if your spouse passes away, God forbid, you can submit a waiver based on your spouse passing. Sorry, guys, I'm like trying to pull my hand lotion because my hands are so dry. The second one is you can remove conditions based on divorce. So I know like a lot of immigrants are so terrified when they hear or their spouse threatens them with divorce or says, oh, I'm going to divorce you. And once I divorce you, you're not going to be able to get your green card anymore. If your spouse divorces you, that's what it is. But really, when we're looking at immigration, we're looking to just make sure in situations like this that the person did have a good faith marriage. It's not that the marriage didn't work. It's that the person truly had a good marriage, real marriage. It's just that it didn't work. So don't let that be what makes you stay in an abusive marriage or in a terrible marriage because of your green card. So, and then of course, the other option to remove with the waiver is based on extreme cruelty and battery. Battery is really battery really means essentially what it means, abusive behavior, whether that's physical, psychological, emotional, and things of that nature. So that's another way to request a waiver. The 1, 2, 3. So the fourth category really is extreme hardship. You can ask for a waiver to remove conditions because your husband is not, or your wife is not able to sign, and it will cause you extreme hardship if they don't remove the conditions. This option is very, 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 how many times did I say very, very difficult to get approved? Let me repeat it again. It's very, 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 very difficult to get approved. So really, you really want to focus, if you're requesting a waiver, on the first three things that I talked about: divorce, death, extreme cruelty, or battery. If you qualify, and fall into one of those categories. Okay. So let's talk about what the requirements are for each of them. So with divorce and death and extreme cruelty or abuse, you don't need to wait 2 years to remove the conditions in your green card. So let's say you get your green card in 2021, your 2-year green card in 2021. Obviously, as of 2022, it's just been a year. But if your spouse has been abusive, you don't need to wait till 2023 to apply for removal of conditions. You can apply immediately. And you will get an additional 2-year extension. Excuse me. So you get an additional 2-year extension from the date on your original green card. So if, let's say, you got a green card in 2021, so your green card will typically expire in 2023. If you file in 2022 because your spouse has been abusive, you'll get an extension till 2025 while they're making a decision on your case. This exemption or this waiver, you can apply for it before the expiration of your green card, or you can do it after the expiration of your green card. If you're doing it on the basis of divorce, you need to wait till you've been divorced, because if you don't wait till you're divorced and then they send you an RFE requesting for your divorce decree and they've not finished it in courts and all of that stuff, you could get denied. So if you're divorced and you have your divorce decree, then you can submit with your divorce decree. Again, with that situation, you can submit it early. If you submit it late, you just have to explain why you submitted it late. With death, if you have a spouse that passes away, you want to submit it, as soon as your spouse passes away. What else do I want to add on this topic? Unlike VAWA cases, when you are removing conditions on your green card and you marry somebody else and you're asking for a waiver, it does not affect you as long as you can prove your marriage was a good faith marriage, as opposed to VAWA. If you submit a VAWA application, if you remarry, your application will essentially be canceled. With conditional green cards, if, let's say, you got divorced and you married somebody else and you're filing for removal of condition based on the first one, that's okay. Once they remove the conditions, you'll get a 10-year green card. Okay, yeah, one other important thing that I want to mention is that if you do get approved based on abuse, like your conditional green card is removed based on abuse, then you become eligible for citizenship within 3 years, and you start counting 3 years from the date that you got your first conditional green card. If it's based on divorce, then it's 5 years. All right, let me take some questions. Jay says, I found out some have same green card number as mine and same birthday and same first and last name, but just middle name different. I'm not really sure what your question is. I'm not really sure what you're asking me. You can schedule a consultation, Jay. 407-995-6567. All right, let me see what you guys have on Instagram. Good morning, Chef Pascal. Let's see what else we have here. How many years does it take to have your case approved with VAWA? Most VAWA cases take 2 years to 2.5 years. that's the window. So you could fall anywhere in there. Like I always say with time, sometimes you might get your stuff approved earlier, sometimes you might get it approved later, but that is just the average of when people get approved. Okay. Okay, so let's see. Do I have any other questions? Does your child who's 4 years old living abroad need a passport to apply for a green card or birth certificate? Well, they can't come to the United States without a passport. So I would recommend that you get a passport. I mean, they don't need it for the I-130 application, but they're going to need it to come into the United States. So that would be a good idea to get them a passport. Gabby says, can you still get an RFE when you get a prima facie determination letter? Absolutely, you can. And this is a common misconception that if you get a prima facie letter, that means you're going to be approved. That's not how it works. Granted, a prima facie letter, for those who don't know, that is what you're giving when you submit a VAWA application. So it's like basically saying that you meet the bare minimum prong, the bare minimum standards. And I might talk about that on my next slide if that's something that you guys want me to talk about. The bare minimum. So they have a bare minimum, and when they look at what you've submitted on its face, it on its face meets the bare minimum requirements. Now, after you're giving your prima facie, then a fine-tooth comb is used to now dissect everything to make sure that everything checks out. So, okay, maybe you've submitted some evidence of like, I don't know, like bills. I'm using as an example, like bills and things to show that you have cohabitation. So on its surface, you meet a prima facie determination. When they now start using a fine-tooth comb, they're now going to dissect those bills and see if it corresponds with the time you guys were married, if the bills make sense, and if they don't have any questions. Yes, a prima facie is a good sign, but it's absolutely not an approval. And it's not a guarantee of approval, and it's not a guarantee that you may not be asked for additional evidence. So they can look through your stuff and say, okay, we need clarification. And one thing I want to point out, guys, is that a request for additional evidence is not doomsday. It does not mean that your case is going to get denied. It means that based on what they have here, they can't make a decision. So they need some additional information to help them make a decision. However, it is very important that when you get a request for additional evidence, you address all the questions that they're asking you for. Like, so if they're saying we need proof to show you have a good faith marriage, we need proof to show you have abuse, or we need proof to show you have no criminal record, it's important that you address all three, not just one or two, because if you address only one or two, they'll take it that is your answer, and in that case, you could get a denial. So make sure you're addressing everything that you've been asked. So Uzama on Facebook says, can you remarry while waiting for your vow to be approved based on divorce or abuse? No, you cannot. If you remarry, you're going to get your vow. You're not going to be able to get a green card via vow. So just wait until it gets approved. Nothing is stopping you from dating somebody, but just don't go remarrying someone. Okay. Ashani said it's not doomsday when you have a great lawyer like this one. Thank you. Yeah, but it's really not doomsday. I mean, I can't even tell you guys how many RFEs we get. And sometimes the RFEs are silly. Like sometimes USCIS even makes mistakes and we have to send them back. Like seriously, like, I remember we just got an RFE saying, we don't have a 485 to approve this work permit. Meanwhile, you have the exact filing receipt that you mailed to us. So, like that's obviously USCIS mistake. So sometimes they're mistakes. The key thing is just addressing and answering what USCIS has asked you for. And same thing with notice of intent to deny. Notice of intent to deny is definitely that is scary. And NOID is scary. Even for us as lawyers, it is scary because it takes quite a bit of legal research and arguments to make, and you just pray that the person that is reviewing your argument agrees with your argument. So whenever it's a notice of intent to deny, those are the ones that I would say be stressed out about, and really, really try to have an explanation for all the things that, you have on there that they have a problem with. Okay. So Sorjo says, I did an interview last August. I still haven't heard anything from them, but I'm divorced before filing for my 10 years. So, Sergio, I don't know what kind of interview you did, whether you did a marriage-based case. I mean, if you're divorced and you did a marriage-based case, obviously you're going to be denied regardless. Or if they mistakenly approve you, by the time you get to citizenship, they're going to take your green card away from you. If you're married, or if you filed based on marriage and you're divorced, you need to actually withdraw your petition because you no longer qualify. If that's not the scenario and you're just waiting for them, I would say first try the 1-800 number, request info pass. If that doesn't yield anything, then you want to try congressional assistance. So reach out to your local congressman based on your zip code, and usually they'll give you a form to complete, and they'll try to see if they can get USCIS to make some sort of movement for you. Okay. So Karen says, I just became a citizen. Does my 4-year-old living abroad automatically become a citizen, or do I need to apply for a green card first? This is actually a really, really good question. So your children derive citizenship automatically if they don't have a green card, if you were a citizen by birth. Okay, so if you just became a citizen, your child needs a green card. Once your child gets the green card, as long as your child is under 18 and in your care, in your custody, your child can derive citizenship from you. But your child doesn't have citizenship by birth because when your child was born, you were not a US citizen. Okay. All right, let's see. I have some questions in the question box. Why is it taking over 1 year after I-485 interviews with no response? The interview was last year, June. Honestly, if you have not received any approval for a year, I would always say you better be prepared for secondary inspection. There's a possibility that, CBP or USCIS might show up to your house, to your job, to go meet your landlord, to your spouse's place of work. Because usually if it's been a year, there's some sort of investigation going on. You can still reach out to USCIS just to find out what's going on. I haven't heard you. I just talked about that like less than 1 minute ago, what the process is. But generally, if it's been that long, expect another interview, which would be a Stokes interview where they separate you and your spouse. And also just expect that they could come and do a home visit with you. Okay. So I had an I-130 pending, but I had to switch to VAWA. Do they automatically switch my priority date from the I-130 to I-360, or how do we do that? Thank you. P and Rachel, the answer to this question depends on if your spouse is a green card holder or U.S. citizen. If your spouse is not a U.S. citizen, if your spouse is a U.S. citizen, the priority date is really irrelevant because visas are immediately available. So it depends on that. Okay, let me see what else. Somebody says, is an EAD card an ID to use on a day-to-day basis, or do you need a state ID? So an EAD, you can use your EAD, which is Employment Authorization Card, or as we all know it as work permit. You can use your work permit, on a day-to-day basis, but you should still get a state ID. Like i.e., if you need to drive or you need a driver's license, it's good to have an ID. Okay. Novia McKenzie says, can you travel with an I-130? Absolutely not. No. So if you are doing an adjustment of status in the United States, well, I guess, actually, let me roll back. When you say, can you travel to I-130, do you mean that you did not do an adjustment of status application? Because if you have a standalone I-130 that's pending and your visa is valid and you have not overstayed your time in the US, you can certainly go back and forth. I mean, you might face some questioning in Customs and Border when you're coming back, but technically you could travel. But if it's attached to an I-485, you cannot travel unless you have a travel permit, because the minute you travel, you would have abandoned your application, and you might not be able to come back, and you would have to start all over again, but this time with consular processing. So the answer to your question depends on what your I-130 is on the basis of. Okay, I can take 2 more questions and I gotta jump off. I have an I-130 processing now, and it's been more than 6 months since the application was filed, but I've still not heard from USCIS concerning the next step. Join the club, Kels. That's everybody else. I-130s are taking, 10 to 12 months for them to make a decision on them. And I personally, my husband is waiting for he's processing for his mother, and it's longer than yours. But, USCIS has published timelines, and you can go on USCIS case processing website just to get in, you type in wherever your service number, your service center is. So like usually in the bottom left of your receipt, and it will tell you what the timeline is. And now they've even taken it a step further where you can actually put in your receipt date, and it will tell you if it's too early for you to do an inquiry. But 6 months is really not a long time for an I-130. Most I-130s, they will make a decision between 8 to 12 months on average. Some people would go longer, but about 80% of people will get it then. Okay. Lotus says, thanks for all you do. You're welcome. Okay, let me see what else. One more question. Inio Bong says, as a green card holder, can I bring my mom over here? I'm assuming here means the US. No, you cannot. The only person or the only children that can apply for their parents are US citizen children who are over the age of 21. You must be over the age of 21, and you must be a US citizen to apply for your parents. As a green card holder, the only people you can apply for are your spouse, unmarried children under 21, or unmarried children over 21. If your children get married, you no longer are eligible to petition for them. Okay. All right, guys. Well, I will be on Friday at around 1:30 or 2. So join me live. Share my videos. Subscribe to my channel on YouTube. Share this with your cousins, aunties, uncles. Share it on WhatsApp. You never know who's going to need the help. And I will talk to you guys later on in the week. Have a good day, everyone. Bye.